Hello everyone, welcome back to our Learning English through Case Law series. In this video we will study Case Law No. 52/2021/L on the validity of the land use rights donation contract when the land use right has not been registered. Including 5 parts, Part 1, Source of the Case Law, Part 2, Overview of the Case Law, Part 3, Content of the Case, Part 4, Assessment of the Court, Part 5. Rules. This case law was approved by the Council of Judges of the Supreme People's Court on November 25, 2021 and announced in Decision Number 594/QDCA dated December 31, 2021 of the Chief Justice of the Supreme People's Court. Case Law Source, Cassation Decision Number 231/2020/DSGDT dated September 30, 2020 of the High People's Court in Ho Chi Minh City on the case Dispute over Inheritance of Property, a dispute requesting to invalidate the contract for donation of the land use rights between the plaintiff, Mrs. Thong Tu, and the defendant, Mr. Tong Tan V. Persons with related interests and obligations include 46 people. Part 2, Overview of the Case Law. Case law situation: the contract for donation of land use rights is made in writing and has been notarized or authenticated. The donor has not registered the land use right due to objective obstacles when the donor died. Legal solutions: in this case, a legally effective contract of donation of land use rights must be determined as valid. Keywords of case law: donating land use rights have not been registered, objective obstacles, the donor is dead, the donation contract has legal effect. Part 3. Content of the case. Plaintiff Ms. Tong Tu, Mrs. Yu, presented the petition as follows. Mrs. Tong Tu's parents are Mr. Tong Van T, died in 2007, and Mrs. LUient T C1, died in 2011, who have 11 children. In 2007, Mr. T died, without a will. On November 16, 2009, Mrs. C1 and her children agreed to make a document to divide Mr. T's inheritance. According to the agreement, Mrs. C1 was allocated many land plots and was granted certificate of land use rights, including plot number 257, map sheet number 16, with an area of 4,149 square meters and plots 6, 18, 31, 32, 51, and 52, map sheet no. 15, area 12,883 square meters, both located in Quarter X, Ward Y, Town Z, Binh Duong Province. Taking advantage of Mrs. C1's old age, weakness, illness, lack of sanity and illiterate, Mr. Tong Tan V, Mr. V, cheated, made Mrs. C1 to sign only page 03 of the contract to donate the land use right on June 14, 2010. Mrs. C1 was not present at the office of the People's Committee, but the chairman of the People's Committee, PC, of Town Y, now a ward, still authenticated the contract of donation of land use rights. The above authentication incident violated regulations on notarization and authentication. With the illegal donation contract, Mr. V was granted a certificate of land use right for the land area of 12,883 square meters. Currently, the land plot number 257 has an area of 4,149 square meters is still registered under the name of Mrs. C1 as the owner. Mrs. Yu initiated a lawsuit, request for the following: declare the donation contract for land use right with authenticate number 111, volume 1/2010 TP/CCSCT/HDGD, authenticated by the People's Committee of Town, now a ward, Y on June 14, 2010 as invalid. Determine the land area with an area of 9,839.9 square meters, excluding the area used by Mr. Tong Van L1 and Tong Van P1, in plots 6, 18, 31, 32, 51, and 52 map sheets number 15 in the land with an area of 3,786.1 square meters. According to the actual measurement results on March 8, 2013, belonging to plot number 257, map sheet number 16 in Ward Y, Town Z is the legacy left by Mrs. C1. Distributing the inheritance of Mrs. C1 in accordance with the law, Mrs. Yu requested to receive the inheritance. In material, defendant Mr. Tong Tan V, Mr. V, presented the following opinion: Mrs. C1 gave Mr. V all the land that Mrs. Yu mentioned above. The donation was done by a contract with legal authentication, and currently, Mr. V has been granted a certificate of land use right for the land area of 12,883 square meters. After being given the land, Mr. V redistributed it to other brothers and sisters in the family, each got a share and transferred it to a number of people using handwritten documents. Currently, Mr. Tong Van L1, Mr. L1, uses 1,597 square meters of land, Mr. Tong Van P1, Mr. P1, uses 2,418 square meters of land out of a total of 12,883 square meters for which Mr. V has the certificate of use right. Mr. V agrees to let Mr. L1 and Mr. P1 continue to use this land. For the land part at Plot 257, after the donation contract is authenticated, Mr. V has submitted a registration application to register for the land use rights, but so far, Mr. V has not been granted the land use right certificate. The reason is because, due to the error of the overall map of this area, the local People's Committee had to correct it, and subsequently, a land use right dispute arose. The above-mentioned land has been used by Mr. V since Mrs. C1 was still alive until now. According to Mr. V, the land use right with an area of 3,786.1 square meters belonging to plot number 257, map sheet number 16 in Ward Y is no longer the inheritance of Mrs. C1 because it has been transferred to the litigants. Therefore, Mr. V does not agree with the petition of Mrs. U. Persons with related rights and obligations are Mr. Tone Hugh H1, Mr. H1, Mrs. Nguyen TG, Mrs. G, and Mr. Tone Van P1, Mr. P1, presented their opinions as follows. The right to use the land area of 3,786.1 square meters in plot number 257, map sheet number 16, and the right to use the land area 9,839.9 square meters in plots 6, 18, 31, 32, 51, and 52 map sheets number 15 in Ward Y is the inheritance left by Mrs. C1, request the court to divide the inheritance according to law. The person with related rights and obligations is Ms. General T. Thursday T1, Mrs. T1, presented the following opinions. The right to use the land area of 3,786.1 square meters in plot 257 is the inheritance left by Mrs. C1, so he asked the court to divide the inheritance according to the provisions of law. For the land use right of 9,839.9 square meters in plots 6, 18, 31, 32, 51, and 52, Mrs. C1 gave it to Mr. V. After that, Mr. V was granted a certificate of land use right and Mr. V has divided the land for Mrs. T1, so Mrs. T1 has no claim on this land. Persons with related rights and obligations: Mrs. Tong Tn1, Mrs. Ni, Mrs. Tong Tn2, Mrs. N2, Mrs. Tong T Kim A, Mrs. A, Mrs. Tong Tan N3, Mrs. N3, and Mr. Tong Fook T2, Mr. T2, expressed their opinion as follows. The properties that Mrs. U requested to divide as mentioned above were given to Mr. V by Mrs. C1 under 2 donation contracts of land use rights, certified by the People's Committee of the town, now award, Y on the same date June 14, 2010. Therefore, that they do not ask for the inheritance division. In case the court divides the inheritance, these litigants agree to hand over the inheritance to Mr. V. The person with related rights and obligations, Mr. Tong Van L1, Mr. L1, presented the following opinions. Originally, the disputed land was passed down from his grandfather and grandmother to Mr. L1's parents. During Mr. L1's participation in the revolution, Mr. Tong Van T, who was Mr. L1's brother, declared, registered, and was granted a certificate of land use right. After that, Mr. T divided Mr. L1 with the land that Mr. L1 is currently living in, with a length of 80 m in plot 18 according to handwritten notes dated December 10, 2002. As for the other disputed lands, Mr. L1 is not involved. Persons with related rights and obligations: Mrs. Nguyen TC2, Mrs. C2, and Mr. Tong Tan T3, Mr. T3, expressed the following opinions. Mrs. C2 is Mr. V's wife, Mr. T3 is Mr. V's son. These litigants disagree with Mrs. U's petition. The person with related rights and obligations, Ms. Tong Nok L2, Ms. L2, expressed the following opinion. Mrs. L2 is the child of Mr. Tong Fook T2 and Mrs. Nguyen TH2. If it is the property of her father or mother, Mrs. L2 requests the court to settle it in accordance with law. The person with related rights and obligations, Mrs. Tong Tien K1, Mrs. K1, presents the following opinion. Mrs. K1 is the daughter of Mr. Tong Van L1. The litigant has no claim in the case, the person with related rights and obligations being Mrs. Nguyen TH2, Mrs. H2, presenting the following opinion. Mrs. H2 is the wife of Mr. Tong Fook T2. Mrs. H2 does not dispute with Mr. V. The person with related rights and obligations, Mr. Nguyen Tan L3, Mr. L3, presents the following opinions. Mr. L3 is the son of Mrs. Tong Tan N3. If it is Mrs. N3's property, request the court to settle it in accordance with law. The persons with related rights and obligations are Mr. Vo Van T4, Mr. T4, and Mr. Vo Van M, Mr. M. Presenting the following opinions: Mr. T4 is the husband of Mrs. N2, Mr. M is the child of Mrs. N2, Mr. T4 and Mr. M disagreed with Mrs. U's claim. The persons with related rights and obligations, Mrs. Tong T2 at N4, Mrs. N4, and Mr. Tong Tan P2, Mr. P2, expressed the following opinions: Mrs. N4, Mr. P2 are children of Mr. Tong Van P1 and Mrs. Vo TB, if it is the property of their parents. The litigants have no claim. The successor of the rights and obligations of Mrs. Vo TB, Mrs. B, presents the following opinion: Mr. Tong Tan P1, Mrs. Nguyen TK2, Mrs. Tong T2 at N4, Mr. Tong Tan P2, Mr. Tong Tan T5, Mrs. Tong Timon T6, Mrs. Tong T2 D1 agreed with Mrs. B's opinion presented and agree with the petition of Mrs. U. Persons with related rights and obligations: Mr. Tran Van D2, Mr. D2, Mrs. Truong TL4, Ms. L4, Mrs. Tran Timon T7, Mrs. T7, Mr. Nguyen Van C3, Mr. C3, Mr. Truong Din P3, Mr. P3, Mrs. Pham T8, Mrs. T8, Mr. Hobot H3, Mr. H3, Ms. Nguyen T9, Mrs. T9, Mr. Lachi V1, Mr. V1, Mrs. Vo T10 T10, Mrs. T10, Mrs. Luong T11, Mrs. T11, Mr. Luong the T12, Mr. T12, Mr. Nguyen Duk T13, Mr. T13, Mrs. La H4, Mrs. H4, Mrs. Luong TM1, Mrs. M1, Mr. Ladon T14, Mr. T14, Mr. Lai Van T15, Mr. T15, Mrs. Du TH5, Mrs. H5, and Mrs. Chu T Kim X, Mrs. X, have the same opinion. The litigants have received the land transfer from Mr. V in handwritten paper, have paid the money and built houses on the land. The transfers were separate agreements with Mr. V. If the settlement of this case affects their interests, the litigants will initiate a lawsuit and dispute with Mr. V in another case. The legal representative of the People's Committee of Town Z, Binh Duong Province, presented the following opinions: Certificate of Land Use Right Number CH00091 and CH00092 dated February 3, 2010 issued by the People's Committee of District Z to Mrs. Nguyen TC1 on the basis of inheritance of land use rights. The issuance of certificates complied with the order and procedures specified in Article 23 of the Circular No. 17/2009/TT-BTNMT dated October 21, 2009 of the Ministry of Natural Resources and Environment. Certificate of Land Use Right No. CH0539 dated August 16, 2010 issued by the People's Committee of District Z to Mr. Tong Tan V on the basis of receiving a donation of land use rights, made in accordance with the order and procedures prescribed Article 23 of Circular No. 17/2009/TT-BTNMT dated October 21, 2009 of the Ministry of Natural Resources and Environment, providing for certificates of land use rights, ownership of houses and other properties associated with property. The legal representative of the People's Committee of Ward Y, Town Z, Binh Duong Province, presented the following opinions: at the request of Mrs. Nguyen TC1, a civil servant of the Justice Department of the People's Committee of the Town, now a ward, Y went to Mrs. C1's house to explain and draft a contract for donation of land use rights with the forms in accordance with regulations. Civil servant of the Justice Department has read the entire content of the contract for donation of land use rights for the parties to hear. After that, Mrs. C1 and Mr. V signed and fingerprinted on the contract in front of the Justice Department officer. At the time of signing and fingerprint, Mrs. C1 and Mr. V were completely sane and voluntary, with full civil act capacity as prescribed by law. After the parties signed and fingerprinted, the People's Committee of the Town, now a ward, Y conducted procedure to authenticate the contract of donation of the land use right. The authentication book is 111 and 112, the book 1. 2010/TP/CCSCT/HDGD on the same day of June 14, 2010, in accordance with the law. In the first instance civil judgment number 17/2019/DSST dated May 9, 2019, the People's Court of Tan Nguyen Town, Binh Duong Province decided as follows: 1. Partially accepted the claims of plaintiff Mrs. Tong Tu against the defendant Mr. Tong Tan V on the dispute over inheritance of property. Dividing the inheritance of Mrs. Nguyen TC1 being the right to use the land area according to the actual measurement of 3,786.1 square meters in plot 257, map sheet number 16 in neighborhood X, ward Y, town Z, now a town, Z, which was issued a certificate of land use rights with the number in the land use rights certificate book CH00091 dated March 2, 2010 in the name of Mrs. Nguyen TC1 as follows. Mrs. Thong Tu is entitled to inherit the land use right with an area of 344 m2, Mr. Tong Van H6. Heirs, including Mrs. Nguyen TG, Tong Min H7, Tong T Kim T16, Tong T Kim P4, Tong T Kim L5, enjoy the inheritance of land use rights with an area of 344.1 square meters. Ms. Thong T Thursday T1 enjoys the inheritance of land use rights with an area of 344.1 square meters. Mr. General Van P1 enjoys the inheritance of the land use right with an area of 344.1 square meters. Mr. Tong Hu H1 inherits the land use right of 344.1 square meters. Mr. Tong Tan V, Mrs. Tong TN1, Mrs. Tong TN2, Mrs. Tong TN3, Mr. Tong Fu T2 and Mrs. Tong T Kim A each inherit the land use right of 344.1 square meters. Dividing the inheritance of Mrs. Nguyen TC1 being the right to use the land area according to the actual measurement of 3,786.1 square meters in plot 257, map sheet number 16 in neighborhood X, ward Y, town Z, now a town, Z, which was issued a certificate of land use rights with the number in the land use rights certificate book CH00091 dated March 2, 2010 in the name of Mrs. Nguyen TC1 as follows. Mrs. Thong Tu is entitled to inherit the land use right with an area of 344 m2, Mr. Tong Van H6. Heirs, including Mrs. Nguyen TG, Tong Min H7, Tong T Kim T16, Tong T Kim P4, Tong T Kim L5, enjoy the inheritance of land use rights with an area of 344.1 square meters. Ms. Thong T Thursday T1 enjoys the inheritance of land use rights with an area of 344.1 square meters. Mr. General Van P1 enjoys the inheritance of the land use right with an area of 344.1 square meters. Mr. Tong Hu H1 inherits the land use right of 344.1 square meters. Mr. Tong Tan V, Mrs. Tong TN1, Mrs. Tong TN2, Mrs. Tong TN3, Mr. Tong Fu T2 and Mrs. Tong T Kim A each inherit the land use right of 344.1 square meters. Noting the willingness of Mrs. Tong TN1, Mrs. Tong TN2, Mrs. Tong TN3, Mr. Tong Fu T2 and Mrs. Tong T Kim A on handing over the entitled share to Mr. Tong Tan V. Thus, V is entitled to inherit the land use right with an area of 2,065.6 square meters, in terms of the plants, on whoever's land the plants grow, that person will manage and use them. 2. Do not accept the claim of plaintiff Ms. Tong Tu about delaying the contract of donation of land use rights, certified as 111, Book 1/2010/TP/CCSCT/HDGD by the People's Committee of the Town, now award, Y on June 14, 2010 invalid. Determine the area of 9,839.9 square meters in plots 6, 18, 31, 32, 51, and 52, map sheet book 15 according to the land use right certificate so CH00539 issued by the District People's Committee, now the town, Z on August 16, 2010 for Mr. Tong Tan V is the inheritance of Mrs. Nguyen TC1 and divided the inheritance of Mrs. Nguyen TC1 being the rights to use the land area of 9,839.9 square meters, in plots 6, 18, 31, 32, 51, and 52 sheets of Book 15 in Ward Y, Town Z, Binh Duong Province. 3. Terminate the claim of plaintiff Mrs. Tong Tu regarding the land area of 1,597 square meters in Plot 18 and an area of 2,418 square meters in Plot 6 in Ward Y, Town Z, Binh Duong Province. In addition, the court also decided on the court fees, costs of measurement, valuation, expertise, liability for late execution, and the right of appeal of the involved parties. On May 20, 2019, Mr. Tong Tan V appealed and request to amend the first instance judgment in the direction of not accepting the entire petition of Mrs. Yu. On May 22, 2019, Mrs. Yu appealed against the first instance judgment, asking the Court of Appeal to accept the entire petition of the litigant. In the Appellate Civil Judgment No. 276/2019/DSPT dated November 27, 2019, the People's Court of Binh Province decided as follows: not accepting the appeal request of plaintiff Mrs. Tong Tu, defendant Mr. Tong Tan V, partially adjust the first instance judgment about the court fee. Other contents of the first instance civil judgment No. 17/2019/DSST dated May 9, 2019 of the People's Court of Tan Yuan Town, Binh Duong Province remain unchanged. In addition, the Court of Appeal also decided on the court fees, the rights and obligations to execute the judgment, and the validity of the judgment. On January 6, 2020, Mr. Tong Tan V made a petition requesting the competent court to protest according to cassation procedures against the above-mentioned appellate civil judgment. At the protest decision No. 96/2020/KNDS dated June 22, 2020, the Chief Justice of the High People's Court in Ho Chi Minh City protested a part of the above-mentioned appellate civil judgment, requesting the High People's Court in Ho Chi Minh City to conduct cassation trial to cancel part of the appellate civil judgment on the division of the inheritance of Mrs. LUient T Sảo, which is the right to use the land area, according to actual measurements, of 3,786-1 in plot number 257, map sheet No. 16 in Neighborhood X, Ward Y, Town Z, Binh Duong Province, transfer the case file to the People's Court of Binh Duong Province for retrial according to appellate procedures. At today's court hearing, the representative of the High People's Procuracy in Ho Chi Minh City proposed that the Judges Committee of the High People's Court in Ho Chi Minh City accept the protest of the Chief Justice of the High People's Court in Ho Chi Minh City, partially annulled the appellate civil judgment on the division of Mrs. LUient T Sảo inheritance, which is the right to use the land area, according to actual measurements, of 3,786-1 in plot 257, map sheet number 16 in Neighborhood X, Ward Y, Town Z, Binh Duong Province, transfer the case file to the People's Court of Binh Duong Province for retrial according to appellate procedures. Part 4. Assessment of the Court. Court's findings. 1. Mr. Tong Van T died in 2007, and Mrs. LUient T Sảo died on September 8, 2011, were husband and wife, had 11 children, listed as follows: Mrs. Tong Tu, the plaintiff; Mr. Tong Tan V, the defendant; Mr. Tong Van P1, Mr. Tong Van H6, died on February 18, 2012, married Ms. LUient T G and had the following children: Tong Min H7, Tong T Kim T16, Tong T Kim P4, Tong T Kim L5, Mrs. Tong TN1, Mr. Tong Hu H1, Mrs. Tong TN2, Mrs. Tong T Kim A, Mrs. Tong Tan N3. Mr. Tong Phuc T2, Mrs. Tong T Thursday T1, 2, after Mr. T's death, 2007, on November 16, 2009, Mrs. C1 and the children of Mr. T and Mrs. C1 made a document agreeing to divide the inherited land use rights. The document was certified by the People's Committee of Town Y, District Z, Binh Duong Province on the same day of November 16, 2009. 3. According to the above inheritance division document, Mrs. C1 was allocated with 03 plots of land in Town Y, including a. 854 square meters of land in plot 31, 32, 51 map sheets number 15, b. 17,762 square meters of land in plots 06, 108, 109, 110, 115, 18, 52, 128, 129, 135, 136, 35, 38, 40, 54, 55 map sheets 15, 16, c. 4.119 square meters of land in plot 257, map sheet number 16, 4. After the above property was divided, Mrs. C1 declared, registered, and was granted a certificate of land use rights on March 2, 2010. Thus, from the date of issuance of the lawful land use right certificate, these land plots became the private property of the Mrs. C1 and the litigant has the right to decide on this property according to the provisions of the civil law. 5. Considering, on the same day of June 14, 2010, Mrs. C1 made 02 contracts to donate Mr. V 02 parts of the above-mentioned properties, as follows. The first part of land has an area of 12,883 square meters in plots 6, 18, 31, 32, 51, 52 sheets of map number 15 town Y. The second part of land has an area of 4,119 square meters, in plot 257 map sheets number 16 town Y. The two contracts of donation of land use rights were legally certified by the People's Committee of Y Town on the same day of June 14/2010. 6. After being given the land use right, Mr. V carried out administrative procedures in accordance with the law to change the registered standing user of the land from Mrs. C1 to him. On August 16, 2010, Mr. V was granted a certificate of use right by the People's Committee of District Z for the land area of 12,883 square meters in plots 6, 18, 31, 32, 51, 52 map sheet number 15 town Y, land use right certificate number CH00539 dated August 16, 2010. In this land, Mrs. U only asked to inherit the land area of 9,839.9 square meters, because Mrs. U agreed to subtract the land area that Mr. V had divided for Mr. L1 and Mr. P1. 7. For the land with an area of 4,119 square meters in plot 257, map sheet number 16, town Y, according to the actual measurement results on March 8, 2013 by the first instance court, the land area is 3,786 LM2. Currently Mr. V has not been named the land user. The reason given by Mr. V is that, after submitting the declaration and registration documents to transfer the username from Mrs. C1 to the litigant, the local People's Committee needs to edit the master map of the land, and then the dispute from Mrs. U arose, so the land username registration has not been done so far. 8. Considering, for the land with an area of 12,883 square meters in plots 6, 18, 31, 32, 51, 52 map sheet 15 town Y, in this part of land, Mrs. U's only claims to divide the inheritance for the land area of 9,839.9 square meters because she agreed to subtract the remaining land area that Mr. V had divided for Mr. L1 and Mr. P1. 9. According to the document on division of inherited property dated November 16, 2009 and the contract of donation of land use rights dated June 14, 2010, this land was the private property of Mrs. C1 who gave it to Mr. V, and Mr. V were granted a certificate of legal land use right by the People's Committee of District Z on August 16, 2010, Land Use Right Certificate No. CH00539 dated August 16, 2010. 10. When solving the case, the Court of First Instance and the Court of Appeal determined that the land division with an area of 12,883 square meters in plot 6, 18, 31, 32, 51, 52 of the map sheet number 15 in town Y is the legal property of Mr. V, refused the request for inheritance division on this land. 11. Considering, regarding the land with an area of 4,119 square meters in plot 257 of map sheet 16, town Y, according to the actual measurement results on March 8, 2013 by the first instance court, the area of the land is 3.786, 1m2, 12. At the time of establishing the donation contract of land use rights on June 14, 2010, from Mr. C1 to Mr. V, the 2005 Civil Code was in legal effect. 13. Article 692 of the 2005 Civil Code stipulates the effect of land use right transfer transactions as follows. The land use right transfer takes effect from the time of registration of land use rights according to the provisions of law in accordance with the land laws. 14. Thus, legally speaking, until the recipient of the transfer of land use rights, according to the donation transaction, has not yet registered the land use right for himself, the transferor has died, the donation contract of land use rights shall not have legal effect. 15. Considering the above argument, the Court of First Instance and the Court of Appeal determined that the land area of 4.119 square meters in plot 257, map sheet number 16, town Y, up to now is still the inheritance of Mrs. C1 and has not been transferred to Mr. V, thus accepted the request to inherit request of the property was correct. 16. From a legal point of view, a contract for property donation is a unilateral contract, that is, in this type of contract, only one party has an obligation to the other. Therefore, in some cases such as the specific case mentioned above, the person who was given the land use right has not yet registered the land use right for himself, but the donor has died. The court may consider and recognize the legal effect of the donation contract of land use rights made on June 14, 2010 when determined that this contract is a document expressing the final will of the Mrs. C1 towards the litigant's property for the property, being the document expressing the right to decide on the property before death. Because the following necessary and sufficient conditions were met, 17, the contract has satisfied the conditions prescribed by law on the right to donate land use rights. 18. Until death, the donor of the property has no document to replace the previously signed contract of donation of the property and no action has been taken to show the change of will expressed in the contract. 19. The recipient of the property was unable to register the property, land use right, due to objective obstacles in administrative procedures or other objective obstacles, not because of the subject will of the property's donor. 20. In fact, Mr. V is the person who has possessed, managed and used the donated land since Mr. C1 was still alive until now because the litigant is the youngest son, living with Mr. T, Mr. C1 from childhood until Mr. T, Mr. C1 died. 21. The above argument has also been recognized by the Supreme People's Court in the Appeal Decision No. 470/2013/KNDS dated October 3, 2013 and the Decision on Cassation Review No. 76/2014/DSGDT dated March 5, 2014 of the Civil Court of the Supreme People's Court when dealing with a similar case, a dispute over a contract for donating property between the plaintiff, Mrs. Don Viet T17, the defendant, Mr. Don Phuong B1 and Mr. Don Van K3 occurred in Siê Mau Province. (24) The contract has satisfied the conditions prescribed by law on the right to donate land use rights. 25. Until death, the donor of the property has no document to replace the previously signed contract of donation of the property and no action to show the change of will expressed in the contract of property donation. 26. The person given the property was unable to register the property, land use right, due to objective obstacles in administrative procedures or other objective obstacles, not the subject will of the donor of the property. Part 5. Rules. 1. Accepting the protest number 96/2020/KNDS dated June 22, 2020 of the Chief Justice of the High People's Court in Ho Chi Minh City. Canceling the Appellate Civil Judgment Book 276/2019/DSPT dated November 27, 2019 of the People's Court of Binh Duong Province adjudicating the case of dispute over property inheritance, a dispute over the request to declare the donation contract of land use rights invalid between the plaintiff, Mrs. Tong Tu, the defendant, Mr. Tong Tan V, regarding the dispute settlement of the land with an area of 119 square meters in Plot 257, Map Sheet Book 16, Town Y, District Z, Binh Duong Province, according to the actual measurement results on the day August 3, 2013 of the Court of First Instance. The land area is 3,786.1 square meters. 2. Hand over the case files to the People's Court of Binh Duong Province for retrial according to appellate procedures for the above-mentioned annulled judgment. Content of the case law. 23. When conducting the retrial of the case, if the contract for donation of land use rights established on June 14, 2010 between Mrs. C1, the donor, and Mr. V, the donee, meet all the necessary and sufficient conditions listed below, the validity of the contract must be recognized. Those conditions are: 24. The contract has satisfied the conditions prescribed by law on the right to donate land use rights. 25. Until death, the donor of the property has no document to replace the previously signed contract of donation of the property and no action to show the change of will expressed in the contract of property donation. 26. The person given the property was unable to register the property, land use right, due to objective obstacles in administrative procedures or other objective obstacles, not the subject will of the donor of the property.